Please, Your Lordship, for listing of IS civil for early hearing, Lordship. MSc appeal, Lordship.
When?
Lordship. And can it be on 6th of March, Lordship?
Okay,
Orders.
okay.
Lordship, I beg to mention item number 30 and 31. Here against two LA appeal, 4 review application has been filed. 2 by the state, 2 by the appellate. 2 has been listed today. The other 2 has not been listed. Both are connected, Lordship. So I pray for listing of these 2
When?
today, Lordship. Connected, Lordship.
It has been listed in orders column.
Because it is a review.
Okay, okay.
Yeah.
But have you informed the other side?
Yes, Lordship. I
Okay,
told them that I will.
okay.
May it please, Your Lordship. I beg to mention item number 42. It has been wrongly tagged along with item number 41, Lordship.
What is your prayer?
Lordship, it may be listed for hearing.
It is not connected.
No, Lordship. Separate matters.
41 is the LA appeal.
Yes, Lordship.
Filed by the National Law University.
No, yes. Heard Miss
K. Bhattacharya.
K. Bhattacharya, learned
Mr. G. L. Sahewala.
learned counsel for the respondent number 1. You have informed the other side,
Yes, Your Lordship.
who submits that this appeal has been wrongly listed in orders column along with the LA appeal number 15. LA appeal bearing filing number
Yeah, please, Your Lordship.
15521/. Also heard Miss
Our dance.
R. Das, learned counsel for the appellate. Let this matter be listed for hearing.
Yes, Your Lordship.
Hearing after 2 weeks on a date to be fixed by registry.
Lordship, I also beg to make a prayer for listing of 2 items for orders, Lordship, anytime this week.
2nd of March.
May I please, Your Lordship? Item number 19 in the main list may kindly be adjourned for the day as my learned senior is indisposed.
You have informed the other side.
We are the make appellant.
You are for the appellant.
Yes,
You are for the,
appellant claimant.
have you informed the other side?
They have not arrived yet, Your Lordship.
They have not?
Arrived yet here.
Wait for their arrival. You inform them and then make your mention. Otherwise, we'll take it up in normal course and we may allow your prayer.
May it please the Lordship. Lordship, may I pray for listing of an FAO, Lordship, on 26th if possible, my Lord. A visitation right to the father was denied by the mother, my Lord. To the
26 may not be possible.
Can it be on 27th?
2nd of March.
Oblige, Lordship.
May I please, Lordship? With the concern of the other side, I would like to mention item number 32, Lordship. Lordship, kindly adjourn the matter and fixed after 3 weeks, Lordship.
Why?
Lordship, we have filed one IA we have for improved as respondent. And Lordship, on the last date, the appellant has filed an objection in our IA. Lordship, we will file our reply.
How long it will go on?
Lordship,
Heard Miss, what is your name?
our call, Lordship.
R.
Or
Kaur, appearing for respondent or
respondent in IA.
okay. You have informed the other side,
Yes, Lordship.
respondent.
In IA, we are the
In the interlocutory application, who prays for an adjournment on the ground that they intend to file their reply to the objection filed by the other side against their interlocutory application. She submits that she has informed learned counsel for the other side regarding her prayer for adjournment, who does not have any objection to the prayer. Hence, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
May I please, your lordship, I would like to mention item number 1 for withdrawal as per NS6. One.
Third, Mr.
A Islam.
A. Islam, learned counsel for the petitioner, also Mr. D.P. Goswami, learned additional public prosecutor. Learned counsel for the petitioner prays for allowing the petitioner to withdraw the instant anticipatory bail application. The prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
May I please, Lordship? Lordship, with the consent of other side, I beg to mention item number 26 of daily list, Lordship. Due to sudden personal inconvenience, Lordship, the learned senior could not proceed the matter today.
What is your name?
M. Bora, Lordship.
You are for?
For Lordship appellant.
Heard Mr. M. Bordoloi appearing for the applicant/appellant who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. He submits that he has informed learned counsel for the respondent regarding his prayer for a adjournment, who does not have any objection to his prayer, hence the prayer is allowed. Let this matter be listed on 23rd of March.
May I please, because I beg to mention for listing interest case, my lord. This is my lord, old pending case, my lord.
In orders column, 2nd of March. Yes.
May I please, Your Lordship? I'm praying for listing in order, my lord, the MSc appeal, my lord, 2nd of March.
Okay.
May I please? First, I pray for listing and make appeal any date of March.
2nd
For
of
orders.
March. 2nd of March.
I'm so obliged.
Please, lordship. Lordship, I beg permission for listing of MSc appeal.
Orders column, 2nd of March, 6th of March,
My lord, this is a very urgent.
2nd of March.
May please your lordship, I beg to mention listing of 2 MFAs on 10th of March for hearing.
No, first it will come to orders column on 6th of March.
Lordship, any other date? Already there are matters and
2nd of March.
uh, Lordship, if possible,
Dismissed.
My lordship, similar prayer, listing of make appeal for orders column.
2nd of March.
Okay.
Daily list admission, item 2. May I please, Your Lordship? This is an appeal against the judgment dated 8/2/2022 passed in NEC case number 27 of 2015.
It is yet to be admitted.
Yes, Lordship.
We'll admit it.
So this is a appeal under section 30, lordship. Of the
Substantial question.
of the workman company. So substantial question of law is required. It is not, I think, not supplied, lordship. Only grounders there, lordship.
Oh, where is the substantial question?
It is required.
Lordship, at least 1 week time.
Okay.
Another thing I want to point out, lordship, as per section 30, lordship, before filing appeal, lordship, he has to deposit the awarded amount before the compensation. commission,
Workman
lordship.
compensation.
Section 30, lordship, of the workman compensation.
Is it a requirement?
Yes, that is, and one certificate is also has to obtain from their lordship.
You comply with the requirements.
Section
Uh,
30, lordship.
Please read. Please read. Read slowly.
Yes, lordship. Provided further that no appeal by an employer under clause A shall lie unless the memorandum appeal is accompanied by a certificate by the commissioner to the effect that the appellant has deposited with him the amount payable under the order appeal against.
Have you complied with?
To take instructions.
Heard Mr. M.U. Datta.
NM Dr. Lordship.
Heard Mr. N.M. Datta, learned counsel for the appellant, Also Ms. P. Bhattacharya, learned counsel for the respondent.
Number 1, 2, 1, 2, 3 and 4.
Respondent number 1, 2,
3 and 4.
3 and 4. This appeal under section 30 of the Workmen Compensation Act 1923 has been filed again, impugning the judgment dated 8/2/2022 passed in NEC case number 27/2015 by the learned commissioner, employee compensation, Nagaon, Assam. Learned counsel for the respondent submits that as per the mandate of section 30 of the Employees Compensation Act 1923, the where is the substantial question?
That is not supplied, Lordship. Only grounds are there, Lordship.
No, where is the requirement that?
Lordship, that is section 30, Lordship. Provided that no appeal shall lie against any order unless a substantial question of law is involved in the appeal. And in the case of an order other than the order, such as is referred to the clause B, unless the amount is disputed in the appeal is not less than 300 rupees.
Okay. Yeah, the appeal under section 30 must involve a substantial question of law unless the awarded amount is less than 10,000 rupees. However, in the instant case, no substantial question of law has been stated in the memo of appeal by the appellant. She further submits that there is also a requirement under section 30 of the aforesaid Act to deposit the awarded amount and submit a certificate to that effect from the Commissioner Employees Compensation, which has not been done in the instant case. Therefore, she raises a question of maintainability of the instant appeal. Stop. On this, learned counsel for the appellant prays for some time to seek necessary instruction and to take appropriate steps in this regard. The prayer is allowed. Let this matter be listed on 18th of March. 18th March is okay, or you will need longer time? Okay.
Item 3.
May I please, Lordship? In this case, Lordship, this is the MFA, Lordship. The section 30 of this, Lordship. Workmen Compensation Act, Lordship. Employees. Lordship, I have submitted the substantial question of law, Lordship.
This second proviso is applicable to you.
No, Lordship.
It is applicable only to an employer.
Yeah, Lord. Yes, Lordship. As because lordship, I have the for an insurance company, lordship. And that lordship, the amount is lordship that is disputed, lordship. The company.
What is the substantial question of law?
One lordship, the whether in action there is no police case, lordship. Only on the basis of DD entry, lordship, that the judgment has been passed.
Where is the substantial question?
And in the I think second page of in the lordship appeal, lordship. And lordship, that disability certificate issued by that private doctor, lordship. And there is a no lordship disability, lordship.
Okay, let the other side appear. Heard Miss D.D. Burman, learned senior additional. Oh, sorry.
Advocate, lordship.
Learned counsel for the appellant.
Yeah.
This appeal under section 30 of the Employees Compensation Act 1923 has been preferred by the appellant insurance company within bracket National Insurance Company Limited, impugning the judgment dated 18/7/2025 passed by the learned commissioner, Employees Compensation Barpeta in EC case number 42/2024. Stop. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of April. The question of involvement of substantial question of law in this appeal and regarding admissibility of this appeal shall be decided after appearance of the respondents list accordingly.
Item 4. Please, your lordship. This is a case where the WC case was once dismissed on the ground that the claimant, that the wife of the deceased had taken compensation from another insurance company, New India Insurance Company. This is a case filed by the parents of the deceased. The wife has already taken the compensation from another insurance company. But after dismissal, the case was reopened, lordship. By sending notice to, also said the revision officer sent a notice to New India Insurance Company. But since they failed to respond to confirm, it was again reopened, lordship. The fact remains that this claim has already been settled by a man cannot get benefit under a provision of the act also. He cannot take it from two sources under one.
What is the substantial question?
In page 5 of the year. No, so page 8 also. Page 5 is the page 8.
Wife was given compensation.
Yes, lordship. It was settled in a local law. It was settled for an amount of
Yes.
6,50,000.
Let us frame. We are admitting the appeal.
Yes, lordship.
Heard Mr. R. Goswami, learned counsel for the appellant, also heard Mr. What is your name?
A Hussein Lordship, respondent number
A. Hussein, appearing for respondent number,
one.
respondent number 1. This appeal under section 30 of the Employees Compensation Act, 1923 has been filed by the HDFC Argo General Insurance Company Limited, impugning the judgment and order dated 29/1/2024. Why 2 orders?
Lordship,
You have challenged
orders means one is the earlier order, Lordship, by which it was dismissed.
that order also you are challenging.
I'm not
Ye-
telling that order,
you-
but reference to that dated,
No,
dated,
judgment and-
order is.
Judgment and order dated 29/5/2025. Agottu kati dibo. 29/5/2025. Passed by the learned commissioner, workmen's compensation, Bongaigaon in WC case number 7/2015. The contention of the learned counsel for the appellant is that in respect of the same accident, the wife of the deceased has already been awarded compensation in which case?
In the same case, Lordship.
Same case means? No. What was the case number of the wife?
4709/2015.
Please repeat.
MSC case number 2709/2015. Before the MSCT 3 Kamrup Metro.
272015.
Yeah,
Disposed upon 12/1/16.
In respect of the same extension, the wife, the deceased relative be awarded compensation will be
in the MEC case number
2709.
2709/2015. And as such, the parents of the deceased cannot claim for compensation under Workmen Compensation Act. Stop. After considering the submissions made by learned counsel for both sides, and after going through the materials on record, following substantial question of law is formulated in this appeal, within inverted comma, whether the commissioner, employees compensation Nagaon had acted beyond jurisdiction by reopening a case the wife had filed earlier before employees compensation.
No, Lordship. No, Lordship.
Then which case was dismissed? You read this.
Yes, Lordship, this case was dismissed. I'll read that order. Lordship, may come to page 22 of my memo.
Now that is my query to you.
That this is the same case. It has an order for reopening of the case of 7/15. The case request is put up today. The claimant side has filed a petition praying for review of the dismissal order. Considering the answer of justice, since the petitioner is a mother, this is
Where is the dismissal order? No, your contention is that this case was earlier.
Order itself, judgment itself.
So this case was earlier dismissed.
Dismissed on
So
the.
wife, before approaching MECT, Motor Accident Claims Tribunal, approached the workman compensation.
Dismissed on the ground that MSCT case has been disposed of by settlement. This is the MSCT that payment Order of the local
Can-
judge, page 19, Lordship. Lordship may see page 19,
Deputy Commissioner,
page 19.
Yes, read. Read.
Deputy Commissioner compensation no go detected beyond.
Employees compensation no go.
Compensation no go. Right, reopening.
Reopening the case within bracket case number 7/2015, which was earlier dismissed by it on the ground of pendency of a MAC case. And thereafter, whether he can reopen this said case after the wife who had filed the WC case number 7/2017 was ultimately granted compensation by a motor accident claims tribunal in MAC case number 2709/2015. Stop. Issue notice to the respondents. Since Mr. A. Hussain has already appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the appellant shall take steps. Take steps for issuance of notice upon the said respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of April.
This was dismissed after settlement of the MSCT case, not during pendency, Lordship.
Okay.
After settlement, page 19 will show the decision settled.
During pendency, after settlement of the MSC case. MSC case. Correct. The appeal is admitted. Let the records of WC case number 7/2015 be called for from the Workmen Compensation Bangladesh, from the Commissioner, Workmen Compensation Bangladesh, registry to take steps for requisition in the aforesaid record list accordingly.
The petition for stay.
Lordship, the judgment was passed in favor of the parent lordship. And the insurance companies other, not this appellant insurance company paid to the wife of the deceased person. Some amount may be released from.
No, that is paid by under company in a different case, Lordship.
Lordship,
Okay. One more thing. Whom you have made party? Who is Sumati Chaudhary?
Sumati Chaudhary is the parent, mother.
mother of the deceased.
Okay. No, we'll decide the issue. You have any objection in IA? You file written objection. We are issuing notice. In IA, issue notice. No stay now. Same date.
Item 5.
May I please your lordship? This matter has become infectious, lordship. The original suit has been decreed in favor of me, lordship. So the judgment is.
You are withdrawing. Heard, miss. What is your name?
Lordship.
Heard, Miss M. Burwa. learned counsel for the appellant, who submits that this appeal has become infructuous as the suit has been decreed in favor of the present appellant.
Yes.
And therefore she prays that the appellant may be allowed to withdraw the instant appeal. The prayer is allowed. This appeal is dismissed on withdrawal, on becoming withdrawal stop.
Item 6. Item number 6.
None has appeared for the appellant on call. Let this matter be listed on 6th of March.
Item 7.
Lordship, this appeal is against an order passed by the Railway Claims Tribunal, Lordship. The order is at page 66, Lordship.
What is the order?
Lordship, herein I prayed for waiver of the demurrage charge, Lordship, that was imposed. And on the pretext of demurrage charge, Lordship, they had collected penal demurrage from me. Now there is a procedure, Lordship.
They have collected what?
Penal demurrage.
Penal demurrage.
Yes, Lordship. Under corrigendum 32, which is at page 72.
Okay, we are issuing notice. Heard, Mr. What is your name?
I'm MP Sharma, Lordship.
MP Sharma, learned counsel for the appellant. This appeal under section 23 of the Railway Claims Tribunal Act 1987 has been preferred by the appellant, Messrs. RDS Logistic and Agencies Private Limited, impugning the judgment and order dated 29/10/2025 passed by the Railway Claims Tribunal, Gauhati bench in review application number 6/2025 arising out of original application number 3 Roman 3-22/2024. I have gone through the grounds taken by the appellant in the memo of appeal. Stop. This appeal is admitted. Issue notice. You have served notice on the.
Lordship.
Have you served?
Yes, Lordship. Lordship.
Issue notice. Since learned counsel for the appellant has submitted that he has already served notice on the Deputy Solicitor General of India. Hence, no formal notice need to be issued. Let the records of the review application number 6/2025 as well as original application number 3/2022 3-2022/2024 be called for from the Railway Claims Tribunal, Gauhati bench. The registry shall take steps for requisitioning the records. Let this matter be listed on 25th of March.
Right, Lordship.
Item 8.
May I please, Lordship? My lord,
Yes.
the appellant's, my lord, the prayer for interim injunction was rejected by the my lord, the trial court, my lord. Page, my lord, 108 of the appeal, my lord.
what the trial court has done. Issued notice.
Yes, only,
When is the next date fixed?
next date, my lord, 19-1 was there, my lord. On that day, nothing was done, my lord. Only they even not appeared, my lord, respondents. We took statements.
Thereafter,
Thereafter, no comments.
after 19-1, what was the date? When-
Next date, I have no comments.
You don't know.
No, no. So,
Hmm.
my lord, I'll take that, the date. Till then, my lord, my lord, my interim prayer, my lord, will come.
You don't know about anything about your case.
I know, my lord, case about the case. My lord,
When is the next date? You don't know. No interim relief at this stage. We don't know about the fate of the case.
my lord, so far, my lord, instruction is concerned, my lord,
When is the next date?
I'll take instruction just after few minutes, my lord.
We are issuing notice.
Yes.
Heard, Mr. What is your name?
R.S. Chauhan, my lord.
R.S. Chauhan, learned counsel for the appellant. This appeal under Order 43, Rule 1 within bracket R of read with Section 151 of the Code of Civil Procedure 1908 has been filed by the appellant impugning the order dated 19/2/12/2025 passed by the Court of Learned Civil Justice Senior Division Karbi Anglong in Miss J case number 34/2025 in connection with title suit.
One thing, my lord, kindly see, my lord, one thing. My lord,
Title
date is
suit
25, my lord. On 25, my lord.
25?
25/2. Next date is
Okay.
25/2.
For objection and objection hearing.
Objection hearing, my lord.
So you agitate the matter before the trial court if it is after 2 days. Today is 23rd.
Yes, ma'am. Yep.
So we are not issuing notice. क्या लिखा?
Case number 34 in connection
In connection with title suit number 11/2025. By the impugned order, the trial court had issued notice to the respondents and has declined to grant any ad interim ex parte injunction as prayed for by the applicant. Learned counsel for the appellant has submitted that the Miss J case number 34/2025 is fixed before the trial court on 25/2/2025 for objection and objection hearing. Stop. Since the matter is fixed for objection hearing before the trial court and a short date has been given, this court is not inclined to issue any notice at this stage. Let this matter be listed on 27.
Yes.
27 or first.
27/2. 27/2, my lord.
2nd of March. 2nd of March. In motion, in admission column again. We'll see what happens on
Yes.
that day.
Obliged.
Item 9.
May I please proceed? While is Lord is against the impugned judgment whereby the learned trial court tribunal has passed the award of rupees 19 lakh against the owner of both the vehicle, whereas the present appellant vehicle was not at all guilty as per the police report also.
but the trial court has fastened the liability, equal liability upon the owner of the both vehicle. So that is
Not on the insurance company. Who has been asked to pay?
insurance company. The present appellant has the insurance policy already expired prior to the accident, my lord.
Okay.
And the appellant already, the owner of the vehicle already died.
You are asked to pay 50%.
My lord, owner of the vehicle already died during the pendency of the case in the tribunal. Thereafter, my lord, the wife of the deceased was included as a necessary respondent. So there is no liability upon the as per the facts and records, my lord. There is no liability because the appellant vehicle was ahead of the victim vehicle.
Yes, who are you? You are for?
I am for respondent number 228, my lord.
Who are 228?
They are the claimants. 4 to 8, they are minor, and 2, 3 are the parents of the deceased.
And
I'm appealing for respondent number 10, driver of the appellant.
okay. Heard Mr. I.A. Talukdar, learned counsel for the appellant. Also heard Mr.
Yes, Alim.
S. Alim, appearing for respondent number 2 to 8, as well as Mr. N.I. Khan, appearing for respondent number 1. You have served notice to 1 also.
Yes, I have submitted. Last time one also appeared, my lord.
No, you have to take fresh steps. There was a delay in filing this.
Yes,
appeal.
it was condoned, my lord.
So fresh notice will go to those.
And my learned colleague already appeared in the earlier case, my lord. And I served the copy also as per the direction of the.
No, their appearance will be shown, but against the counsel who is not present.
I'll serve, my lord.
This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by Ms. Rahima Begum Chaudhary, impugning the judgment and award dated 8/1/2024, passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro, in MAC case number 12/2017, whereby
Case number 212.
MAC case number 212 of 2017, whereby the appellant, who is the owner of Innova vehicle bearing registration number AS 01AD 7088, was also directed to pay 50% of the awarded amount, along with the owner of the vehicle bearing registration number AS01BR 8989 to the claimants, along with an interest of 6 at the rate of 6%, 6.5% per annum from the date of filing of the claim petition till the date of realization. Stop. The appeal is admitted. Issue notice to the respondents. Since Mr. S. Alim has already appeared for respondent number 228 and Mr. N.I. Khan has also appeared for respondent number 10, no formal notice need to be issued.
Respondent number 1 appeared, my lord.
I appeal for 1.
No formal notice need to issued to the said respondent. The Mr. A. Bhattacharya also appears for, has appeared for respondent number 1. Hence, no formal notice need to be issued to respondent number 1 also. Let this matter be listed after receipt of records from the Motor Accident Claims Tribunal.
My lord, IA 3660.
On 1st of April. IA is there.
Yes, 3660.
IA,
What stay, my lord?
any objection?
3660, this is for limitation, my lord. It is disposed of.
It has been allowed.
My lord, sorry, my lord, IA 191 to 26.
You will be filing objections.
My lord, we may
For
be
stay.
supplied with the copy of the IA. We are not supplied with the copy.
This interlocutory application heard so and so. This interlocutory application has been filed by the applicant / appellant under Order 41 Rule 5 of the Code of Civil Procedure, praying for stay of execution of the impugned judgment and award as against the present appellant.
H1.
Stop. The within bracket dated 8/1/2024 passed in MSC case number 212/2017 bracket close. The said judgment has been impugned by the applicant in the connected appeal number 31/2026. Learned counsel for the respondent number 2 to 10 has submitted that 2 to 8 has submitted that he has not received the copy of the interlocutory application. You have received? The learned counsel for other respondent have also submitted in the same manner. The applicant is directed to furnish copy of the interlocutory application to the learned counsel for the respondent within 2 days from the date of this order. List along with the connected IA on 1st of April. Any execution cases pending?
Yes, execution case is pending, my lord. But it is already, so far my information, it is stopped now. Due to filing of this MSC appeal.
Then let them file objection.
Yes.
We'll decide.
Yes.
I think your lordship has dictated in the main appeal that the award was passed by MSC 2, but it is passed by MSCT 1, my lord.
Okay. But it is stated here in that MA, Motor Accident Claims Tribunal number 2.
Lordship, kindly come to the judgment.
My lord, it is wrongly, I will correct it, with the permission of your lordship.
In main appeal, learned counsel for the appellant also seeks to correct the typographical mistake as regards the Motor Accident Claims Tribunal, whose judgment has been impugned in this case. How you will correct? You have to file corrected memo of appeal.
My lord, it is only a small minor your lordship can give.
The appellant is allowed to rectify the said typographical mistake in presence of the court master.
Yes. Oblige.
Oblige, my lord.
Item 10.
Please, my lord. It's an appeal against the award of MSCT Golaghat Lordship by the insurance company. Yes. Yes, I'll provide. Lordship, the main ground of my appeal is that, Lordship, there are two vehicles involved in this case. And initially, the affair was registered against the other vehicle, that is a Tata Sumo vehicle, Lordship. And the evidence of the claimant clearly indicates that there was some rash and negligent driving by the vehicle Tata Sumo, Lordship. It's evident at page number 16.
So you have been allowed, also
Again-
asked to pay 50%.
Yes, Lordship. 50-50 was given, but we have adduced two DWs, Your Lordship, defense evidence
Okay,
regarding this. And one thing is there, Lordship. Another ground is there, Lordship. Here, loss of income, disability is there, Lordship, and disability has been counted as 30%. In that regard, disability has been awarded, loss of income, Lordship. But in addition, Lordship, without any document, only on assumption, Lordship, because the claimant was hospitalized only for 19 days. And there was no medical certificate regarding his bed rest or further treatment was submitted. And that Learned Tribunal had taken 6 months as his loss of income. That was counted as 338,640. But he was only hospitalized for 19 days. And in addition, Lordship, again, loss of income was calculated at the rate of 30%, Lordship, because double benefit has been given to this claimant, Lordship. And already pain suffering has already been awarded, Lordship. That is, in my view, it's little high, Lordship, because there is no evidence on record that he was not able to work for 6 months, or there was any medical certificate.
Is it an injury case?
Injury case, Lordship. Injury case.
Okay. Yes, Mr. Goswami, anything? We admit the appeal.
You don't have a copy of the memo. I'm not in a
Yes.
position to make any submission.
I appear for respondent number 1. The award is in my favor. Rafi will kindly see.
No, we will admit the appeal, will not grant any stay.
Let them deposit 50% of the awarded amount.
Lordship,
You're paying for it.
50% of the 50%, because 50-50 was awarded.
Okay.
50% they have already paid.
I'm
Okay.
ready, Lordship. There is a stay also, stay petition also.
Okay.
ICICI Lombard has already paid 50%.
Okay.
We are ready to pay 50%.
Heard
of the
Mr.
50%.
P. J. Burman, learned counsel for the appellant. Also heard Mr. P. Bhomik, learned counsel for the respondent, number 1, as well as Mr. R. Goswami. You are appearing for respondent number 1.
1. I appear.
Mr. R. Goswami, appearing for respondent number 4. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the National Insurance Company Limited, impugning the judgment and award dated 13/11/2024, whereby 13/11/2024 passed in MAC case number 42/2013 by the Motor Accident Claims Tribunal Golaghat, awarding rupees 32,26,424 to the claimant, along with an interest at the rate of 9% per annum from the date of filing of the claim petition till realization stop. The present appellant was directed to pay 50% of the awarded amount. The other insurance company, that is respondent number 4, was directed to pay remaining 50% of the awarded amount. I have gone through the grounds taken by the appellant in his memo of appeal. So this appeal is admitted. Issue notice to the respondents. Since Mr. P. Bhomik has appeared for respondent number 1 and Mr. R. Goswami has already appeared for respondent number 4, no formal notice need to be issued to the said respondent. Stop. As regards other respondents are concerned, comma, the appellant shall take steps for issuance of notice upon them by speed post as well as by usual mode within 7 days from the date of this order, returnable on 1st of April 2026. Stop. Let the records of MAC case number 42/2013 be called for from the concerned motor accident claims tribunal. The registry to take steps for requisitioning the aforesaid records. List the matter accordingly.
2175.
217. There is.
But delay has already been disposed. 729, I think this.
Where is the stay application? There is no stay application.
Yes, Lordship, there was 2175.
It is not listed. 217 code.
It might not be listed today, but it is 2175 of 2025.
Let it be listed. We
Lordship.
list accordingly.
Lordship, may kindly fix a date for listing of the IA.
IA is not before me.
No, for stay.
No, stay IA is not before this court. It is not listed today. It will be listed. We don't know. It may be listed on the next date.
The next date is not known to me.
1st of April.
1st of April will be too long, my lord.
Till then, there is no stay will be in operation. You can go for execution.
I've already gone for execution.
They have already filed an execution case because we are ready to deposit 50% of the 50%.
But you have not filed the IA. IA is not.
I is the Lordship. For stay, there is 2175, 75 or 25. That is the stay application.
Lordship, that's why I'm saying a date may be fixed for listing of the IA at an early date.
Learned counsel for the appellant in appealote continue koribo. Learned counsel for the appellant has also submitted that the appellant has filed an interlocutory application under Order 41 Rule 5 of the CPC, praying for stay of execution of the impugned judgment and award. Stop. However, the said interlocutory application is not listed before this court. The registry is directed to list the aforesaid. Any filing number is there?
I have the IA number, Lordship, 2175 of 2025. 2175 of 25.
Registry is directed to list the aforesaid interlocutory application. When?
Early date, Lordship.
On 7th.
7th.
6th of March.
6th of March.
6th of March.
Lordship, mobilize.
Main case 1st April. IA 6th of March. Along with the main case.
Item 11.
देखा जाए.
May I
Yes.
please, my lord?
Yes.
My lord, this is an appeal against the final judgment awarded to the appellant of this particular petition on 10/1/25 for compensation of 18 lakh.
Your case was dismissed. You are the claimant.
No, man, I am the opposite party of the alia.
You are the appellant in this case.
Yes, I am the owner of the vehicle.
My lord, myself for the respondent number 1, 2, and 3, my lord.
Okay.
My lord, I have filed an IA for direction to deposit 50% from the awarded amount, even though today is not listed that IA, my lord.
Is there any stay application?
No, my lord.
we are praying for stay in this matter.
Just a minute. Heard Mr. What is your name?
And Gogoi.
N.
I'm appearing on behalf of A. Saran
Heard Mr. N.
and Gogoi.
N. Gogoi, learned counsel for the appellant. Also heard Mr. B. R. Das, learned counsel for respondent number 1, 2, and 3. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the appellant Sri Shuneshwar Das, impugning the judgment and award dated 10/1/2025, passed in MSC case number 791/2020 by the Motor Accident Claims Tribunal number 1, Kamrup Metro, whereby Kamrup Metro in MSC case number MSC case mentioned Korisune, MSC case number 791/2020, whereby a compensation amount of rupees 18,14,460 was awarded to the claimants along with an interest at the rate of 6% per annum from the date of filing of the claim petition. This appeal is admitted. Issue notice to the respondents. Since Mr. B. R. Das has already appeared for respondent number 1, 2, and 3, no formal notice need to be issued to said respondent. As regards respondent number 4 and 5, the appellant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable on
My lord, we have an interim prayer in
6th of April. ISNA. Interim prayer. You have filed an interlocutory application.
No, my lord. In this appeal itself, of course, there is a jurisdictional error. The learned tribunal, that is number 1, Kamrup, was not supposed to try this because all the parties are from Jorhat. And
No, this is an appeal. You have to file an interlocutory application for stay. If you file an I taking all your pleas. File an separate interlocutory application. Okay. List accordingly.
My lord, item number 13, can it be taken, my lord? This is also my.
No, you wait for your turn.
Okay, my lord. Okay.
My lord, kindly direct them to furnish the copy of memo of appeal, my lord. Today is the.
Lordship, hearing the claim petition of the appellant was dismissed, your lordship, on the ground of not submitting the evidence on some occasion, your lordship.
Okay.
Page 23, your lordship, kindly have it.
Heard Mr. A. M. Khan.
Herein, I am only seeking your lordship, if your lordship will remand back the matter, your lordship.
No, for that is your grounds have to be considered. They may agitate. Furnish. You have not even furnished the memo of appeal. Heard Mr. A. M. Khan, learned counsel for the appellant. Also heard Ms. M. Sharma. L. Sharma, learned counsel for respondent number.
For the insurance, my lord.
For the respondent number 1. And 2. This appeal under section 173 of Motor Vehicles Act 1988 has been filed by the appellant impugning the order dated 29/10/2024 passed in MSC case number 368/2022 by the Motor Accident Claims Tribunal, Goalpara, whereby the claim petition filed by the present appellant was dismissed. The appeal is admitted. Let the notice be issued to respondent. Since Ms. L. Sharma has appeared for respondent number 1 and 2, no formal notice need to be issued to the said respondent. However, the appellant is directed to furnish requisite copies of memo of appeal along with the annexures to the said respondent. As regards other respondents, the appellant shall take steps for issuance of notice upon them by speed post as well as by usual mode within 7 days from the date of this order, returnable on 1st of April. Let the records of MSC case number 368/2022 be called for from the concerned tribunal. The registry shall take steps for requisitioning the records list accordingly.
Item 14.
12.
May I please, Lordship? Yes. Sir, I have filed this appeal, Lordship, against the judgment and awarded the 3/3/2025, Lordship. Only on the Lordship ground that the Learned Tribunal, Lordship, holding that the personal expense of the deceased is 1/4, Lordship, instead of 1/5, Lordship. And the deceased has left behind 4 Lordship dependents.
So you are aggrieved by the quantum. Heard Miss D.D. Burman, Learned Counsel for the appellant. Also heard Mr. B.R. Das, appearing for respondent number?
My lord, respondent number 1 to 4.
1 to 4. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by the appellant insurance company, impugning the judgment and award dated 3/3/2025, passed in MSC case number 39/2021 by the Motor Accident Claims Tribunal, Sibsagar. The appellant is mainly aggrieved. The appellant by the aforesaid judgment and award, the appellant was directed to pay a compensation amount of rupees 12,07,500 to the respondents. In this appeal, the appellant is aggrieved mainly with the quantum of the compensation awarded to the claimants. Stop. This appeal is after perusing the grounds mentioned in the memo of appeal, this appeal is admitted. Let the notice be issued to the respondents. Since Mr. B.R. Das has appeared for respondent number 1 to 4, no formal notice need to be issued to the said respondent. You have furnished the copies?
Yes, my lord. Memo of appeal copy has to be furnished. And my lord, 50% of from the awarded award may be granted, my lord.
Wait. The appellant is directed to furnish a copy of memo of requisite number of copies of memo of appeal along with the annexures to the Learned Counsel for the respondent within 7 days from the date of this order. As regards the other respondents, the appellant shall take steps for issuance of notice upon them by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of April. List accordingly. Any stay application? You deposit 50%. Heard Miss D.D. Burman, learned counsel for the applicant. Also heard Mr. B.R. Das, learned counsel for the claimants / respondents. Stop. This interlocutory application has been filed by the applicant insurance company in connection with MAC appeal number 67/2026, praying for stay of execution of the impugned judgment and award dated 3/3/2025, passed by the Motor Accident Claims Tribunal, Sibsagar, in the MAC case number 39/2021. Stop. Learned counsel for the applicant submits that the applicant has impugned the aforesaid judgment and award in connected MAC appeal number 67/2026, which has already been admitted, and notices have been issued to the respondents. She submits that the insurance company is also ready to pay 50% of the awarded amount as a condition for grant of stay of execution of the impugned judgment. Mr. Das, you don't have any objection?
No objection, my lord.
Since the learned counsel for the claimant / respondent does not oppose the submission made by learned counsel for the applicant, notice to respondent number 6, 5, and 6 is waived in this case, and this interlocutory application is allowed. The applicant insurance company, no, continue. The impugned judgment and award dated 3/3/2025, passed in MAC case number 39/2021 by the Motor Accident Claims Tribunal, Sibsagar, is hereby stayed during the pendency of the connected MAC appeal number 67/2026, subject to deposit of 50% of the awarded amount by the applicant before the registry of this court within a period of 6 weeks from the date of this order. Stop. In the event the applicant deposits the aforesaid amount, the registry shall disburse the same to the respondent / claimant number 1 to 4 after proper verification. This interlocutory application is accordingly disposed of.
My lord, interest may be granted.
Next item.
Item 14.
Highly obliged.
Wait, please, your lordship. My lord, my junior colleague would like to place the case.
Item number
14, madam.
Your Lordship.
Yes.
Your Lordship, this is an appeal under section 173 of the Motor Vehicles Act. Your Lordship, the learned tribunal in this case awarded pay and recovery rights to the insurance company. As such, Your Lordship, one of the main grounds of our appeal is that after the 2019 amendment, the pay and recovery rights no longer exist.
Okay, we are admitting anything you are for?
Claimant clause.
Heard Miss A. Biani, learned counsel for the appellant. Also heard Mr. This is item number?
14.
Mr. A.T. Sarkar, appearing for respondent number 1. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the appellant Messrs. New India Assurance Company Limited, impugning the judgment and award dated 3/10/2024, passed in MSC case number. What is the MSC case?
2077 of 2019.
MSC case number 2077 of 2019 by the Motor Accident Claims Tribunal number 2, Kamrup Metro, Gauhati. Stop. I have perused the grounds taken by the appellant in the memo of appeal. This appeal is admitted. Issue notice to the respondents. Since Mr. A.T. Sarkar has appeared for respondent number 1/claimant, no formal notice need to be issued to the said respondent. As regards other respondents are concerned, the appellant shall take steps for issuance of notice upon those respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of April. Let the records of MEC case number 2077/2019 be called for from the concerned tribunal. The registry to take steps for requisitioning the aforesaid records. List accordingly. Stay any objection?
Subject to 50% may be released.
Your Lordship, we are ready to deposit 50%, but release may not be allowed at this stage until and unless the owner appears, Your Lordship.
Take another time's lordship. 50% may be released, lordship. We are ready to lordship, execute the bond, lordship.
Your Lordship, we are.
No, we are not, we are allowing the stay petition subject to deposit of 50% and issuing notice to owner. You file an IA for seeking release of the, if you have a case. Heard, Miss, same parties. This interlocutory application has been filed by the applicant insurance company in connection with MSC case number, MSC appeal number 69/2021. 2026, praying for stay of execution of the stay of execution of the judgment and award dated 3/10/2024, passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro at Gauhati in MSC case number 2077/2019. Issue notice to the. You have filed any execution case?
No, not yet.
Okay. We are not granting stay now. We are issuing.
Judgment is in my favor.
We are issuing
They
notice.
have not challenged the quantum of award, lordship. So, lordship, 50% may be released. I'm ready to.
You are only challenging your liability.
Yes, Lordship.
According to you, the owner should pay.
Yes, Your Lordship, the tribunal also held that the owner is to be made liable because the deceased was a gratuitous passenger. There's a definite finding to that effect, Your Lordship. As such, if the amount is released at this point, it would be very difficult for the insurance company.
We are ready to execute the bond, lordship.
No, their plea is after some Supreme Court judgment, such an direction could not have been passed. That is your no.
Yes, Your Lordship, we are challenging pay and recovery, right?
Issue notice to the opposite parties. Since Mr. A.T. Sarkar has appeared for respondent number, opposite party number 1, no formal notice need to be issued to the said respondent, said opposite party. However, as regards the other opposite parties are concerned, the applicant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of April.
Lordship will furnish by the course of the day.
The applicant is directed to furnish copy of memo of appeal along with the interlocutory application with annexures to the respondent, learned counsel for respondent number 1 during the course of the day.
Item 45 from supplementary list.
May I please refer your lordship? Lordship, there is a delay of 23 days. An application under section 5 of the Limitation Act with 173 of the Motor Vehicles Act 1888. There is a delay of 23 days.
Lordship, may I pay one supplement?
You are
She is not aware about the status of the case. That has been already allowed.
condoned. Delay has been condoned.
On last occasion, Lordship, it was came up for Lordship in mediation column. So my legal friend was not there. So my honorable court has directed to appear today, Lordship. Fixing.
What happened in mediation?
So we are ready to send the case for mediation if they are agree also, Lordship.
Yeah, whether it can go to mediation.
As your lordship is.
Instead of mediation, it may be fixed before Lok Adalat on 14.
Before, yes.
Is there any hope?
From our part, Lordship, we are ready to.
You are insurance company.
We are insurance.
Should we be ready to pay 50% of?
No, let us send it to Lok Adalat.
Loss.
Heard Mr. J. Kolita, learned counsel for the appellant. Also heard Miss, what is your name? D. Chakraborty, learned counsel for respondent number 1 insurance company. No, who is the?
Claimant, Lordship. Appellant is an insurance company.
You are for?
Insurance company appellant.
Ms. D. Chakraborty appearing for the respondent number
1, Lordship.
1 lordship.
1. It is submitted at bar that there is an element of settlement in this appeal, and therefore a request has been made to refer this matter to ensuing Lok Adalat on 14/3/2026. The prayer is allowed. Let this matter be listed before ensuing Lok Adalat on 14th of March 2020.
Item 46.
May please lordship. Appeal may be admitted and 50% may be, with a like amount, 50% of immunity bond. Because it's the analogous case also same aspect. There is a another analogous case. It's admitted with 50% along with the furnishing the like amount of immunity bond.
Here it is a small amount only.
Maybe.
If 55,000 is 56,000, I'll be getting 50%.
You don't want that.
Huh?
You don't want.
But the indemnity bond, it will cost a
Similar amount also, another case also.
So indemnity bond should not be there.
No, you have to indemnify in case. What is your ground in the appeal?
This accident is very disputed, and his employment also disputed.
Heard Mr. R.C. Paul in appeal, main appeal. Heard Mr. R.C. Paul, learned counsel for the appellant. Also heard Mr. A.R. Agarwala, appearing for respondent number
1.
One, my lord.
1. This appeal under section 173 of Motor Vehicles Act 1988 has been filed by the Oriental Insurance Company Limited, impugning the judgment and award dated 18/2/2025 passed by the Motor Accident Claims Tribunal Dhubri in MSC case number 11/2015, whereby the appellant was directed to pay a compensation amount of rupees 1,22,000 along with an interest at the rate of 7% per annum to the claimant. Stop. The appeal is admitted. Let the records of the MSC case number 11/2015 be called for from the concerned tribunal, the registry to take steps for requisitioning the records. Let also notice be issued to respondents. Stop. Since Mr. A.R. Agarwala has appeared for respondent number 1, no formal notice need to be issued to the said respondent. The appellant is directed to furnish a copy of memo of appeal along with annexures to the learned counsel for respondent number 1 during the course of the day. As regards other respondents, the appellant shall take steps for issuance of notice on those respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 8th of April. Yes, Sunil. This interlocutory application has been filed by the applicant insurance company in connection with MAC appeal number 423/2023, praying for stay of execution of the impugned judgment and award, stay of execution of the judgment and award dated 18/2/2025 passed by the Motor Accident Claims Tribunal Dhubri in MSC case number 11/2015. Stop. Learned counsel for the applicant has submitted that the aforesaid judgment and award has been impugned by the present applicant in the connected appeal number 423/ connected MAC appeal number 423/2025. He submits that the applicant is also ready to deposit 50% of the awarded amount as a condition or grant of stay of the execution of the impugned judgment and award. Stop. Since the claimant is represented by his engaged counsel, Mr. A.R. Agarwala, considering the submissions made by learned counsel for the applicant, notice to other respondents is waived and this interlocutory application is allowed. The applicant, the judgment and award, the aforesaid judgment and award shall remain, the execution of the aforesaid judgment and award shall remain stayed during the pendency of the MSC appeal number 423/2025, subject to deposit of 50% of the awarded amount by the applicant insurance company before the registry of this court within a period of
6 weeks.
6 weeks from the date of this order. Stop. In the event the aforesaid amount is deposited by the insurance company, same shall be disbursed by the registry to the claimant Muhammad Nurul Islam after proper verification and and subject to deposit of an indemnity bond to the extent of the amount to be disbursed to him. This interlocutory application is accordingly disposed of.
Much of it.
Orders, item 15.
Lordship says we have prefer the appeal, my lord, on the ground, only one ground, my lord, quantum, my lord. So this matter may be sent to coming Lok Adalat, my lord.
Yes.
Your Lordship, this matter pertains to quantum and the appeal has been pending since 7 years, Your Lordship. Deposit of 50%.
No, my lord.
No.
It is already admitted, my lord.
Admitted.
There is a
interlocutory, Your Lordship. It's for orders.
there is a hope of. Is there any stay?
No, my lord.
Not stay.
Stay is there, my lord. But we are not pressing, my lord.
Let it go to Lok Adalat. Try your luck.
Yes, my lord. On 13th of March, my lord.
13th or 14th.
14th of March, my lord.
Heard Miss L. Sharma, learned counsel for the appellant. Also heard Mr. N. Iqbal.
Claimant respondent number 1.
Learned counsel for the claimant respondent number 1. Learned counsel for the appellant insurance company has submitted that since this appeal, in this appeal, the appellant insurance company is mainly aggrieved only with the quantum of compensation awarded to the claimant. There is a hope of amicable settlement between the parties, and therefore she prays for listing this matter before the ensuing Lok Adalat on 14th of March 2026. Learned counsel for the claimant does not oppose the prayer. Hence, the prayer is allowed. List this appeal before the ensuing Lok Adalat on 14th of March 2020.
Item 16.
May it please your lordship. Your lordship, in this matter, respondent number 3 has expired, and we have already intimated the insurance company. So, and we have received instruction from the insurance company.
You have to take steps.
Yes, your lordship.
Heard Mr. S. Datta, learned counsel for the appellant, who submits that the respondent number 3 has expired in this case, and the matter has been intimated to the appellant insurance company. An instruction in this regard is awaited. He submits that some time may be granted to the appellant so that appropriate steps may be taken by the appellant in this regard. The prayer is allowed. But this is when he expired.
Your lordship, in the year, I think 2023. So we have intimated the insurance company, but till now they could not acquire.
How many respondents are there?
3 respondents, your lordship. 1 and 2, they have already appeared.
So against 3 it will abate if you are not taking.
Yes, your lordship.
So we are passing the order of abatement.
Yes, your lordship. We will have to file abatement, setting aside abatement and also.
Cut off. Last line continue. It appears that on last date also, same prayer was made by the appellant before this court, and the appellant was granted one last chance to file appropriate application. However, it has failed to do so. Learned counsel for the appellant submits that the respondent number 3 has expired in the year 2023. Therefore, it appears that this appeal against respondent number 3 has a bit. Who is respondent number 3?
Dilip Singh, he's the owner, Your Lordship.
Has abated.
Dilip Das, Your Lordship.
Is abated. The registry to make endorsement regarding the abatement of respondent number 3 on the memo of appeal. Stop. List this matter. Records are there.
Yes, Your Lordship. LCA received.
And who is appearing for 1 and 2?
Mr. M. Deka, Your Lordship.
List this matter for hearing.
Yes, Your Lordship. Meanwhile, we will file our setting aside.
No,
amendment.
that is on you. We are not making any.
Okay.
We have passed orders for abatement. List this matter for hearing on 7th of May.
Item 17.
Here, service is complete, Malad. There is a MSC.
For respondent. One.
This is condonation application.
Malad, condonation petition, Malad. Here, Malad,
Condonation petition of 22.
yes, Malad. Service was not complete, that is why some there. Recently, service completed, Malad.
My lord, I'm appearing for respondent number 1 today.
1.
So, lordship, there is a delay, substantial delay, I can see in the.
How much delay?
440
Delay
days.
is
So
Malad,
in this regard, 440.
798 days.
Malad, COVID period has been deducted, Malad. Let me support.
No, just a minute. How many respondents are there?
Respondents are 4 respondents, Malad. Respondent number 1 is the insurance company, and respondent number 2 is the driver.
Who is representing 2?
My lord, earlier he appeared, my lord. He appeared on, my lord, 30/11/2022. Office notice there.
Okay.
3 and 4, madam.
3 and 4, Mr. Vishwas.
Yes.
Okay. Now what is your case?
My lord, here, my lord, it's tribunal passed an order for pay and recovery. It was found during my lord, trial. It was found that the driving license was not, my lord, genuine. So, my lord, driver is the different person. So, my lord, Lanet Tribunal directed the insurance company to pay the compensation and thereafter to recover the amount from the owner. Now, my lord, here, my lord, if kindly come to lordship page 33. 33 are the, my lord, orders of the Lanet Tribunal. Here, my lord, order reflects, notice was never issued. And nowhere it is stated that the proceeding will proceed ex parte against the owner and driver. Kindly come to my lord, page 33.
No, in the claims case.
Yes, my lord.
No, but here you have to explain the delay.
Delay part will come, my lord.
We'll go to that issue later on.
Yes, my
In
lord.
there, I'm filing objection, lordship.
No, yes, that is why I am submitting, because I never received summon.
Oh, that is one of the reasons.
Yes, my lord. I am submitting that I never received any summon from the tribunal. I received the summon only when the insurance company filed an application for recovery.
Okay.
So that is why this is relevant. I am coming, my lord, this order.
Yes, you will be filing objection.
So let him file, my lord.
Because I haven't gone through the petition yet. I haven't got. a
Yes,
copy.
Mr. Vishwas.
I have to go through.
You have appeared
Let them
today
file.
only.
Learned friend already filed.
Today only I paid.
Heard Mr. N. Kolita, N.K. Kolita,
Yes.
learned counsel for the applicant. Also heard Mr. P.J. Burman, learned counsel for the respondent number 1, as well as Mr. S.C. Bishwas, appearing for respondent number 3, and 4. It appears from
Sure.
record that the notice on respondent number 2 has been duly served, and he had appeared also on earlier occasion by his engaged counsel. Therefore, this interlocutory application may be heard. Stop. However, learned counsel for respondent number 1 submits that he has appeared in this interlocutory application today only and seeks some time for filing written objection. The prayer is allowed. Short date. March. 6th of March.
6th of March. Well,
Let this matter be listed again on 6th of March.
obliged.
May I please, your lordship? Your lordship, in this matter, there is a delay of 4 days.
4.
4 days, yes, your lordship.
You're opposing? No. Heard, Mr. What is your name?
Iranglube.
A.
Iranglube. IRANGLUBE. For A.G. Chaudhary.
A. Rangobai. What is the spelling?
IRANGLUBE.
Difficult. Learned counsel for the applicant. Also heard Mr. R.C. Paul.
Respondent number 1.
Learned counsel for respondent number 1. This interlocutory application has been filed by the applicant / appellant under Section 5 of the Limitation Act, read with proviso to Section 173 within bracket 1 of the Motor Accident Claims Tribunal 1988, praying for condoning the delay of 4 days in preferring the connected appeal, whereby the judgment and award dated 8/12/2021 passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro at Gauhati in MAC case number 86/2017 has been impugned. Learned counsel for the claimant, learned counsel for the insurance company / opposite party, considering the short period of 4 days delay only, does not raise any objection against this delay condonation application. Stop. I have gone through the reasons cited by the applicant in its delay condonation application. Considering the reasons stated therein to be sufficient ground which prevented the applicant in approaching this court within the prescribed period of limitation in filing the connected appeal, the delay of 4 days is hereby condoned and this interlocutory application is allowed. Stop. Registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by it.
Item 19.
Nineteen. Yes.
Your Lordship, the respondents are not yet present in the case, Your Lordship.
You sought for adjournment.
Yes, my Lordship. My senior is indisposed to do.
This I is for
For continuation of delay,
how much delay?
227 days.
Third miss, what is your name?
Nikita Priyadas.
And
Nikita, Nikita.
what is the title?
Das.
Third miss N. Das, learned counsel for the applicant. None has appeared for the respondents, though the service on the respondents was complete as notice were duly served to them. Stop. An order to this effect was passed by this court on 22/10/2025. Therefore, this court is proceeding ex parte against the aforesaid respondent. This interlocutory application has been filed by the applicant Shri Bhaskar Jyoti Kalita, praying for condonation of delay of 275 days in preferring the connected appeal, whereby the appellant has impugned the judgment and award dated 3/8/2019, passed in MAC case number 209/2016 by the Motor Accident Claims Tribunal number 1, Kamrup Metro, Gauhati. I have gone through the reasons mentioned for the delay by the applicant in the in paragraph number 2 to 4 of the instant instant interlocutory application. After going through the said reasons, this court is of considered opinion that same may be regarded as sufficient cause which prevented the present applicant in approaching this court by filing the connected appeal within the prescribed period of limitation. Hence, this interlocutory application is allowed and the delay of 275 days in preferring the connected appeal is condoned. The registry is directed to register the connected appeal and list the same for admission after a week on a date to be fixed by it.
Item 20.
Please, your lordship. So this IA is for delay condition.
In this case, I am paying 3 days time for filing opposition. Here was delay of 1,202 days.
Heard, Miss, what is your name?
PM Ahmed.
PM?
Ahmed.
PM Ahmed, learned counsel for the applicant. Also heard Mr. K.K. Bhatta, learned counsel for respondent number 1, who seeks a short accommodation for allowing the insurance company, respondent number 1, to file written objection against the prayer for condoning the condonation of delay made by the applicant. The prayer is allowed. Let this matter be listed on
6.
6th of March. 6th of March.
Item 21.
Lordship, service is complete. And the appeal has been admitted, Lordship.
I have appeared for.
Heard Miss
K. Bhattacharya.
K. Bhattacharya, learned counsel for the appellant. Also heard Mr. M.J. Kadir, appearing for
5 and 6.
respondent number 5 and 6. As well as Miss, what is the B. P. Sharma, appearing for respondent number 1 to 4. It records, I said,
Yes, sir.
it appears from record that the appearance of parties in this appeal is complete and the records of the trial court have already been received. Hence, it is ready for hearing. Let this matter be listed for hearing on 7th of May.
Item 22.
May I please, your lordship? Lordship, the MCR has been received, lordship. A date will be fixed for hearing. I am for the respondent claimant, lordship.
None has appeared for the appellant on call. Mr. What is your name?
A.U. Ahmed on behalf of K. Bhattacharya.
Mr. A.U. Ahmed, appearing on behalf of Mr. K. Bhattacharya. Learned counsel for respondent is present. This case is ready for hearing. Hence, list it for hearing on
24.
21st of April.
21st.
Item 23.
Please, your lordship. Lordship, the office note says that neither the AD card nor the service report has been received, lordship. The lordship, we have taken the steps on
Way back.
2024, yes.
You have to take fresh
Yes,
steps.
sir. And this step, lordship may grant us to take on upon dusty, lordship, because
Additionally on this,
additionally on dusty.
heard Miss Aidas, learned counsel for the appellants. On perusal of the office note dated 19/2/2026, it appears that the service report in respect of notices issued to respondent number 1 and 2 have not been received. Stop. Learned counsel for the appellant prays for allowing the appellants to take fresh steps for issuance of notice on the respondents. The prayer is allowed. The appellant is directed to take fresh steps for issuance of notice by way of speed post as well as by usual mode on respondent number 1 and 2 within 7 days from the date of this order, returnable on 8th of April. Stop. Additionally, the appellant is also allowed to take steps for issuance of notice by dusty mode. Stop. In the event the appellant is able to serve the notice by way of dusty mode, he shall file an affidavit in compliance thereto on the next date fixed. List this matter again on 8th of April.
8th of April.
Item 24.
In this case, I appear on behalf of the respondent today, Lordship. Today is the first day, Lordship, we have received notice,
You are appearing for?
sole respondent, Lordship.
Okay, so appearance is complete.
Otherwise, Lordship, it's a misprobate case which they had filed, Lordship. It was dismissed for the delay was not condoned. Against that dismissal order, they filed a misj case before the learned district judge. Now they have come up in appeal. Whether appeal would be maintainable, Lordship. Today,
Appeal against,
the order of the district judge in a misj proceeding. Lordship. Let the matter come up next week. Today I am handicapped, Lordship. I have, although records are there, Lordship, is not.
okay. What is your name?
J. Mosang.
Heard Miss J. Mushahari
Mosang,
Mosang.
appearing for the petitioner.
J. Mosang appearing for the appellant. Also heard Mr. A. Ganguly appearing for the sole respondent, who submits that he has made his appearance in this appeal today only, and also submits that this appeal also submits that the issue of maintainability of this appeal is involved, and he seeks some time to get necessary instructions and make his submissions as regards maintainability of this appeal on the next 8 weeks. The prayer is allowed. Let this matter be listed on 6th of March.
Six, I have other matters also, 5 or 7th, any day. Lordship.
7th. Oh, no, 7th.
Saturday.
5th.
5th March.
5th
Item
of March.
35, people.
Much obliged.
No, please, madam. IA number 608, Lordship. This is a delay condonation application. The Honorable Court has to direct the petitioner to take step upon the respondent. But coincidentally, also we have not taken.
Notice has not gone.
Yes, Lordship, we have not taken step. Lordship. So, well, my humble prayer, my lord, at least 2 days time will be granted to the petitioner to take fresh step. Lordship.
Heard Mr. N. Chaudhary.
M. Das, Lordship. My name is not.
Heard Mr. M. Das.
Yes, Lord.
M. Das, learned counsel for the applicant. This application under which case is
608 is the delay condonation application.
608 dio.
747 is the Lordship to stay attention.
That will
This is after the
delay condonation.
delay condonation.
608 Utma. Learned counsel for the applicant submits that due to some miscommunication, the applicant could not take steps as was directed by this court by its earlier order, and he seeks some accommodation to allow the applicant to take fresh steps. The prayer is allowed. The applicant is allowed to take fresh steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 8th of April.
Okay, good. Item 27.
Yes,
And again for S number 3.
none has appeared.
My lord, I'm sorry.
Yes.
My lord, I'm for the appellant, my lord, here. IA has been
You are
filed for
for,
condonation of delay.
you're for,
As per our three insurance company.
3. And 2 is served by office note dated 29/4/2025.
one,
1 has not been served. I have to take fresh steps on response number 1.
who is one?
1 is the driver.
You take fresh steps.
My lord.
When have you taken last? Stop. Heard Mr. A. Bhattacharya, learned counsel for the
Applicant.
applicant, also heard Mr. K. Bhattacharya, K. Bhatto, appearing for the respondent number 3. It appears that the notice issued to respondent number 2 has been duly served on earlier occasion. However, the notice service report in respect of notice issued to respondent number 1 has not yet returned. The applicant is directed to take fresh steps for issuance of notice on respondent number 1 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 8th of April.
8.
Item 28.
May I please be with you? So this is prayer for withdrawal of the 50% of the amount deposited before the registry of this null court. And this case is also going to be settled, already discussed. So this file is little bit large, so it has gone to head office. So if 50% is released, then they will can settle here itself. Last time Lord Sri also asked the learned senior Adi Majumdar. So I humbly submitted this stage to release the 50% of the amount. So next it can be settled, Lord Sri.
Yes, Mr. Sharma.
Lordship, there is no objection regarding that. Actually, I do not have any instruction regarding that. But however, Lordship, we are ready to withdraw the 50%
Yes, Lord.
to them, but providing the deposited bond.
Lord Sri, they are going to settle. So
No, if it gets settled,
that is also
then it's okay, but deposit indemnity bond.
okay,
Heard
Lord.
Mr. A.R. Agarwala, learned counsel for the applicant. Also heard Mr. S.P. Sharma, learned counsel for the insurance company. This interlocutory application has been filed by the applicant / claimants praying for allowing them to withdraw the 50% of the awarded amount which has been deposited before the registry of this court by the insurance company in pursuant to the which was the order in pursuant to the order dated
5/2/25, Lordship, if I'm not wrong.
31/7/2024. By which order?
What are your next, Lord Sri? Last part of that was the good in the IA Lordship. This is last part.
By order dated 31/7/2024, passed in IA within bracket C number 2221/2024. in connection with MAC appeal number 361/2024. Stop. Learned counsel for the applicant has also submitted that there is a possibility of amicable settlement in the pending connected appeal also. Stop. Learned counsel for the insurance company does not oppose. You are not.
But there is one point, Lordship, as my learned senior said that there is a possibility of settlement. Then they may get even an amount which is more than 50%.
Yes.
So if we release an amount now, it will be little difficult. So
No.
only because of the factor of settlement. Otherwise, we have no difficulty in for them to withdraw the 50% with a bond.
Learned counsel for the insurance company has submitted that he has no objection in this court dispersing the deposited amount to the applicant/claimants subject to payment, subject to furnishing of indemnity bond. So considering the prayer made by considering the submissions made by learned counsel for both sides, this interlocutory application is allowed. The registry is directed to disburse the 50% of the awarded amount deposited by the insurance company before it in pursuant to the aforesaid order, to the claimants.
Claimant number 1, Lordship. Wife
Why?
of the deceased, Lordship.
Why claimant number 1?
Because you are son and daughter, Lordship. So 50% will be released to them. Wife, mother of indemnity board, she will give the indemnity board. Otherwise, the 4 indemnity board will be required, Lordship.
No, to all the claimants. To the claimants after proper verification by the registry. Subject
Indemnity
to.
by only one, Lordship.
Why only one?
Because all children and baby minor, Lordship. Indemnity board will be given by on behalf of all. Indemnity board will be given by the wife only.
Learned counsel for the appellant submits that since the other claimants are sons and daughters and son of the claimant number 1, she may be allowed to receive the disbursed amount on behalf of other claimants also. And she is ready to deposit indemnity bond to that effect. Stop. The registry to disburse the aforesaid amount to claimant number 1, Srimati Manika Pathar, alias Monica Pathar, after proper verification, subject to furnishing of indemnity bond to the indemnity bond of rupees 45,29,405 with an undertaking to deposit the same in the event the appeal filed by the insurance company is allowed and an order to that effect is passed by this court. This interlocutory application is accordingly disposed of.
Lordship, with the main appeal, Lordship, a reminder for LC, at least 10 copy of the LC may be recorded.
Lordship, I have not received the copy, Lordship, or it is the position of Lordship.
Otherwise, service is complete because response number 5 and 6 has already been started.
Heard Mr. S.P. Sharma, learned counsel for the appellant. Also heard Mr. A.R. Agarwala, learned counsel for respondent number 1 to 4. It is submitted by learned counsel for the appellant that by order dated 5/2/2025, the names of respondent number 5 and 6 have already been completed. Hence, the names of have already been struck off, and therefore the appearance of parties in this appeal is complete. Stop.
I have not received the copy of appeal.
It appears that the record of the concerned MSC case has not yet been concerned MSC case concerned Katidiop. Record of the MSC case number 1002/2022 has not yet been received. Issue reminder for the same. If there is a possibility of settlement, then why don't you go for mediation?
No, Lordship, we had a heavy discussion with the company, Lordship, but it is nearly 1 crore is the amount, Lordship. 1 crore. So after receiving this 50%, then their file will be within their limit, Lordship, 50 lakhs. So that is
outside the jurisdiction of the regional office.
Okay, list check.
I have to receive the appeal memo.
Furnish a copy of memo of appeal. I'm not reflecting it in the order sheet. You furnish it. 20.
Item 29.
Your Lordship. According to the office note dated 9/11/9/12/2025, Your Honor, we have taken the steps, but we have not submitted the written up notice, Your Honor. May be allowed to take steps again here.
Heard Mr. R. Senswa.
Yeah, yes, sir.
What is your name?
R.A. Locker, appearing on behalf of R. Sensor.
Heard Mr. R. A. Locker, appearing on behalf of Mr. R. Senswa, learned counsel for the appellant. On perusal of the office note 9/12/2025, it appears that the appellant has taken steps for issuance of notice on the respondent without any written up notices. As such, the notice could not be sent to the respondent. Learned counsel for the appellant prays for some time so that he may rectify the defects in taking steps for issuance of notice on the respondent. The prayer is allowed. Let the appellant shall take fresh steps for issuance of notice upon the, how many respondents are there? Upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 8th of April. List accordingly.
Item 30, 31 and production list item 1.
As a matter of fact, your Lordship disposed of the LA appeal. Now, the application is filed by both the parties. Some cases were not listed today. My learned friend has made a prayer for calling for those records.
Whether those records have arrived?
May I pray that this matters may be fixed on a hearing day for final disposal, because
Yes.
the matters will take some time.
Yes. When choose a date.
We have chosen a date of 17th, is a Tuesday, madam. 17th March.
Okay. Common order.
In all 4 reviews.
In 30, 31, 32, as well as production list. Item number 1.
item দুটা আছে নে production দুটা আহিব লাগে
With claims.
with
Stop. Reflect, show the name of all the councils in respective review petitions. Abhishek, वो देख के from the cause list it is
Yes.
Stop. It is submitted by at bar that these review petitions have been filed by the appellants as well as respondents in connection with, there was a common judgment
common judgment.
in connection with common judgment and order dated 1/11/2025 passed by this court in LA Appeal number 2/2019
And LA appeal number 3.
and LA Appeal number 3 of 2019. Learned counsel for both sides have prayed for listing this matter on a hearing day, preferably on 17th of March 2025 for final disposal. The prayer is allowed. List these matters on 17th March.
Apply.
Item 33.
वो Abhishek, पहले वाले order में 32 is not involved. 31 production is.
Yeah, please, Your Lordship.
Yes.
Lordship, this IA has been filed for allowing for early hearing in this matter. Actually, the applicant, she is a cancer patient, as in the last.
Any objection?
No, Your Lordship. No.
Choose a date.
Next week, any date, Lordship. TCR has been received.
5th of March.
Acha.
Heard, Mr. What is your name?
Yes, Nag.
S. Nath, learned counsel for the applicant. Also heard Mr. S. Datta, learned counsel appearing for the
Opposite party number 1.
opposite party number 1. This application has been filed under by the applicant slash you are respondent in the
I'm the respondent number 1 in the main appeal.
slash respondent number 1 in connection with MAC appeal number 400/2025, praying for an expeditious hearing of the connected appeal on the ground that the applicant is suffering from cancer. Stop. The learned Mr. S. Datta, learned counsel for the insurance company, does not oppose the prayer. Stop. Considering the submissions made by learned counsel for the parties, as well as grounds stated in the interlocutory application, the prayer made therein is allowed. Let the connected MAC appeal number 400/2025 be listed for hearing on 5th of March. This interlocutory application is disposed of.
Much
Item 34.
May I please, Lord? The IA has been preferred to allow us the withdraw the deposited 50% amount, Lordships.
Lordship will file objection.
Objection
Objection.
heard. Mr.
M. Hawk, Lordship.
M.
Hawk.
M. Hawk, learned counsel for the applicant. This application, this interlocutory application has been filed.
May I pay one thing, Lordships?
You have mentioned wrong provision in the let them file objection.
Lordships.
Praying for allowing the applicants to withdraw the 50% of the awarded amount which has been deposited by the respondent insurance company, opposite party insurance company, in terms of order dated 2/2/2024, passed in IA number 239/2024. Stop. Learned counsel for the insurance company, Ms. M. Saikia, has prayed for allowing the insurance company to file a written objection against the prayer made by the applicant. The prayer is allowed. Let this matter be listed on 18th of March for filing written objection. In the main
Main appeal, Lordship, service is complete. Respondent number 1 and 3 has filed Wakalatnama, and notice of respondent number 4 was received by his wife. LCR has also been received as per office note dated 17/12/20.
Mr. M. Sakia, learned counsel for the appellant. Also Mr. M. Hawk, learned counsel for the respondent number. Respondent number?
Well, 1, 2, and 3. 2 is a minor, Lordships. 1, 2, and 3. 2 is minor, Lordships.
1, 2, and 3.
2 is the minor, Lordships. He is represented by his mother, Lordships.
It appears from office note dated what happened to respondent number 4?
Notice was received by his wife, Lordship.
Where is the office note?
17/12/25.
Okay. As per office note dated 17/12/2025, it appears that the notice to respondent number 4 has been served on the wife of the respondent number 4. Stop. The notice on the said respondent is held to be duly served. The appearance of parties in this case is complete. It also appears that the records of the MSC case number 73/2018 has also been received. Hence, this case is ready for hearing. Let this matter be listed for hearing on 5th of May.
Please, Lordship.
Item 45.
Yes.
So this application is filed for condonation of delay of 280 days in filing this first appeal.
Have you taken steps?
Oh, no, my lord, notice has not been issued. On the earlier occasion, there was some error there.
Heard Mr. O. Loskar, learned counsel for the applicant. This application under section 5 of the Limitation Act 1963 has been filed by the applicant for condoning the delay of 280 days in filing the connected regular first appeal, whereby the applicant has impugned the judgment and decree dated 39/2024 passed in money suit number 12/2019 by the Court of Learned Civil Judge Senior Division Karimganj. Issue notice to the respondent. How many respondents are there?
Respondents are three.
Respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of April.
Item 36 and 37.
See request settlement. None has appeared for the petitioner on call. List this matter on 2nd of March, not 2nd of March, after 7th due,
11th of March.
11th of March.
Item 38.
May I please your lordship? Lordship, steps has been taken on 28/5/2026, lordship.
No, I am appearing on respond number 1. I have filed today itself. I have filed.
You have filed objection.
No, I have no.
You don't have objection. You are claiming.
Yes.
Heard, Mr. What is your name?
A.U. Ahmed.
Heard, Mr. A.U. Ahmed, learned counsel for the applicant. Also heard Mr. A. Khanikar, learned counsel for respondent number 1. Who is appearing for the insurance company?
None appears, lordship.
Notice to insert. Notice has been served.
Report not come, lordship.
It appears that notice issued to respondent number 2 has not yet returned. The registry is directed to place the track consignment report in respect of notice issued to respondent number 2 by speed post before this court on the next date fixed. Let this matter be listed on 25th of March.
Item 39.
May I please your lordship? Lordship, as per service report, as per office notice, lordship, respondent number 1 and 2 address left, lordship.
So what is to be done?
3 weeks may be granted for correct address, lordship, collector.
Okay. Heard, Mr. What is your name?
A.U. Ahmed, lordship.
A.U. Ahmed, learned counsel for the applicant. He submits that as per office note dated 19/2/2026, the notice sent to respondent number 1 and 2 have returned with an endorsement within bracket addressee left return to senders, inverted comma close. The applicant may be granted 3 weeks time to find out the correct address of the respondent number 2 and 3, and thereafter take necessary
Two lordship.
1 and 2,
One.
and thereafter take necessary steps in this regard. The prayer is allowed. Let this matter be listed
Lord,
out.
three service report yet to receive lordship. Respondent number 3.
It appears that notice issued to respondent number 3 has not yet been received. Registry is directed to place the postal track consignment report of notice sent to respondent number 3 by speed post on the next date fixed. List this matter on 30 March.
Item 40.
May I please your lordship? My lord, as per office notice dated 6/2/26, service has not been completed. Await for service notice.
What is your name?
G.A. Sangma, sir.
Write her name. Learned counsel for the applicant. On perusal of the office note dated 19/2/2026, it appears that the notice sent to respondent number 1 and 2 have not yet returned. Stop. The registry is directed to place the postal track consignment report of notices sent to respondent number 1 and 2 by speed post, on the next date fixed. Let this matter be listed on 20 March 2026.
Item 41.
Next, please. Lordship, kindly peruse office note dated 22/2026. My service is awaited upon respondent number 1 matter.
Heard, Mr. What is your name?
V was for my lord. My lord, your lordship has other matter fixed on 27/3/2026, my lord. So list along with IA number 337.
Heard, Mr. D. Basfar, learned counsel for the applicant. Also heard Ms. D. Burman, learned senior additional government advocate appearing for respondent number 2 and 3. On perusal of the office note dated 22/2026, it appears that notice to respondent number 1 has not yet been received back. Stop. The registry is directed to place the postal track consignment report of the notice sent to respondent number 1 by speed post on the next date fixed. List this matter again on
Is there incident to be continued, my lord?
27/3/2026. Yes.
Interim is there, my lord. Interim to be continued, my lord.
The interim order granted earlier shall continue.
Along with the IA number 337/2025.
Continue till next date. List this matter on along with IA number
337/2025.
337/2025.
Item 43.
I have a condemnation of delay of 647 days. Listed for first time, Lordship.
Notice
Yes, Lordship.
served.
No, Lordship, notice has not been sent as yet. You will
For
receive
the
it the first time.
Heard Mr. S.P. Sharma, learned counsel for the applicant. This interlocutory application has been preferred by Oriental Insurance Company Limited under Section 5 of the Limitation Act. For condonation of delay of 647 days in preferring the connected appeal, whereby the order, judgment and order dated 14/2/2022 passed in EC case number 247/2022 by the learned Commissioner, Employees Compensation Borbetta has been impugned. Stop. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of April.
Lordship, judgment and order dated 14/12/22. Lordship had dictated 14/2/22.
14/12/2022.
Obliged, Lordship.
Item 47 from supplementary list.
My lord, we have to substitute here, my lord, but till the date, my lord, they have not given the name of legal heirs, my lord. So we have to await, my lord.
You find out names.
Yes, my lord. It may be fixed last month of March, my lord.
It
In
is
the
a
meantime-
very old pending case.
My lord, we have to substitute the legal heirs of respondent number 1.
When he has died.
2022, they have submitted last 2025, 26, my lord. I have collect, my lord.
Okay. Heard Miss L. Sharma, learned counsel for the appellant, who submits that the learned counsel for the respondent has not
Furnish.
informed about the legal heirs of deceased respondent number 1 to the present appellant, and therefore she seeks some more time to get information regarding legal heirs of the deceased respondent number 1 and take appropriate steps for
Substitution. No.
for filing necessary applications in this regard. The prayer is allowed. Let this matter be listed
Last week of March, my lord.
on
25th March.
25th of March.
Obliged, my lord.
Item 48.
May it please the Lordship. Lordship, this matter is ready regarding service and records.
May applicant. See, TCR also received, so matter may be come up for hearing.
Heard Miss
This is
P.
first.
P. Sakya.
M. Sekya, Lordship.
Sorry. Heard Miss M. Sakya, learned counsel for the appellant. Also heard Mr. S.I. Akan,
Respondent number 1 and 2.
learned counsel for respondent number 1 and 2. It is submitted at bar that this appeal is ready for hearing. Hence, list this appeal for hearing
As usual, boss.
on 5th of May.
As usual. boss.
No,
Oh.
5th of
Which dog?
May.
Oh, I'm so obliged.
Item 49.
May it please be me, Lord. As per office note dated 20th February, Lordship, respond number 1 is not served, returned, answered, and others are not returned, Lordship. So reconciliation could may kindly be for remaining respondent and remaining.
When have you taken steps?
I've taken steps last 6 weeks, I think. If take consignment report is, then
Okay.
reminder for LCR.
Yes. Heard Mr. A.R. Agarwala. And respondent number 3.
Respondent number 3, Lordship, this is driver, so in the next date we can start of it.
Heard Mr. A.R. Agarwala, learned counsel for the appellant. On perusal of the office note dated 22/2026, it appears that the notice issued to respondent number 1, 2, and 4 have not yet returned. Stop. The registry is directed to place the postal track consignment report of the notices issued to aforesaid respondent by speed post on the next date fixed before this court. Stop. It also appears that the unserved notice of issued to respondent number 3 has returned with a postal endorsement within inverted comma. No such persons in the address. Stop. The appellant shall take appropriate steps in that regard in view of the office note. Stop. It also appears that the connected MAC case has not yet been received from the concerned tribunal. Stop. The registry shall issue reminder for the same. Let this matter be fixed on 30 March.
Hearing item 44.
In this case, Lordship, on the last occasion, also directed me to produce a search sheet of the CID PS case number. But Lordship, as for in fact information, Lordship, that is submitted before the CGM Kamruk.
Regarding what?
This is the MSC case, Lordship. The case was dismissed on the fake, no? Fake.
Fake.
And the CID CID is directed to investigate the matter.
Against the errant police officer who issued the accident information report.
My lord, we are the appellant. We may give the background of the case, my lord.
No, so it has been charge sheeted.
Yes, Lordship.
Now, what has happened in this case?
My lord, may I submit, my lord, I am the appellant.
Yes.
My lord, the appellant's husband died in the motor accident. She filed a claim petition for compensation. MSCP dismissed the claim petition and directed the CID to investigate the case. Thereafter, the CID investigated and reportedly they have submitted the charge sheet, my lord. On the last occasion, Honorable Court directed the government advocate to produce copy of the charge sheet submitted by the CID. That's the case, my lord.
Lordship, in this case, unknown truck was involved in the accident as per the initial report. And subsequently, the police issued an accident information showing a Maruti car, Lordship. That is why the case was dismissed on the basis of the evidence of the DW. And the court direct the CID to investigate the case and submit the report. Accordingly, the CID investigated the case and submitted charge sheet against the errant officer who issued the
Against the?
CID.
Against whom the charge sheet was laid?
Against the errant police officer who issued the false accident information report.
Yes.
CID case number is 4 of
No, let him submit. We can hear this matter.
Yes.
Can this be disposed of today? Why?
Without charge sheet.
Oh, you are saying that the copy of charge sheet would be required.
Yes, yes.
My lord, let me make a little submission. My lord, so far as we understand, this in respect of this case, my lord, the MSCT committed perhaps mistake when the claim petition was dismissed, and there was a doubt in the mind of the tribunal that it's a fact case. If the tribunal thought it is a fact case, then before dismissing the claim petition, investigation could have been directed. And MSCT ought to have waited for the outcome of the investigation. What the tribunal has done, on the one hand, claim petition has been dismissed, on the other hand, CID has been directed to investigate. Now, my lord, kindly think about this situation. If the outcome of the investigation comes in our favor,
But it is not in your,
I mean in favor of the claimant, then what will happen?
but it is not in your favor.
My lord, only charge sheet has been submitted. We'll have to wait for the result. Charge sheet is not the final, I mean the end of the.
But prima facie some materials were found.
Prima facie materials, my lord, your lordship will examine the whole matter. As your lordship is sitting over the appeal. So, my lord, after going through the whole case, your lordship will find, my lord.
Okay, no, we can
Only-
dispose of the appeal.
Yes.
Because whether erring police officer is liable or not, that the criminal court will decide. We will decide the appeal on the basis of material before us.
Kindly.
Yes.
Kindly see the finding of the judgment also.
Page number?
It's number 9. It's number 9 also.
Yes.
It's number absolutely fine. The claimant produced exhibit 1 police report, which shows that the Maruti car bearing number was involved in the accident, and Dhula PS registered a case file. Yes, case number 127 of 06 under section 279 338 304A IPC, but the result of the investigation is not known. According to the insurance company, the accident was not caused by the Maruti, but was caused by an unknown truck who managed to run away from the place of accident. In support of the examined DW1 Hemanta Kumar Sharma insurance investor during investigation, he collected the certificate copy of FIR which filed by ASI Drunobora of Dhula Police Station in connection with the PS case number 127 of 06. It transferred from the certificate copy of FIR Exhibit A that one Soyad Ali, son of Aviruddin of Khatoniapara village, informed that the bullock cart was knocked down by unknown truck and one person died and another person sustained injuries. The concerned assistant ASI visited the place of accident and found bullock cart was hit by an unknown truck, and after coming from the spot, he filed an FIR whereupon a case file number 127 of 06 was registered. The investigator recorded the statement of Muhammad Ali Akbar, which has been marked as Exhibit B. The investigator stated that he has recorded a statement of one witness, and from the statement also found, it is found that the unknown truck recorded the disease on the night of 23/9/2006. The FIR was lodged by the concerned ASI on 5/10/2006 for the accident which took place on the night of 23/9/2006. No explanation has been offered by any of the sides regarding the enormous delay in filing the FIR. It transpired from the FIR that the case was registered on the basis of the FIR lodged before the police, and there is nothing on record to say that any prior FIR was lodged by the claimant before police regarding the accident. The police report Exhibit A was issued on 7/5/2007. That is after filing the FIR. From the PM report Exhibit 2, it is found that the postmortem on the dead body was conducted by Mongolway Civil Hospital on the night of the accident itself. By strangely enough, no FIR was filed at that time. On full scrutiny of the evidence on record, I am the considered view that it is a collusive case, and police of Dhula police on being approached by the claimant must have substantially issued the police report. Exhibit 1 showing the Maruti car as the offending vehicle in place of unknown truck, which in fact caused the accident and managed to run away. For the aforesaid reason, I am not intended to grant any compensation to the claimant, and the claim stand dismissed. I think that it would be appropriate to direct the crime investigation department to conduct a thorough investigation and take appropriate action.
Okay, let us hear the appeal. We'll dispose of this after hearing. You make your submission.
Yes, my lord.
Because this is a very old pending case.
Yes, my lord.
Of 2014.
From 2006, my lord, the case is.
The appeal is pending since 2014. We have to only decide whether the tribunal was right or wrong,
Yes, my lord.
and whether the materials available on record are sufficient to reach the conclusion which has been reached by the tribunal, or a contrary conclusion maybe.
My lord.
Yes, yes.
That will
please.
be the correct approach, my lord. My lord, in this respect, I may be allowed to submit, my lord. The things are clear from the impugned judgment passed by the MSCT. Here, my lord, certain important points, your lordship will nothing to my lord, the in this case, my lord, the appellant examined, my lord, two witnesses, the appellant herself and PW2. Lutfur Rahman, he was the eyewitness, my lord. He accompanied the deceased. PW2, my lord, he accompanied the deceased. Two persons were in the bullock cart, and that cart was hit by the Maruti car, offending vehicle. So, my lord, this Latifur Rahman eyewitness was examined as PW2. His evidence is the most relevant and reliable in this case. Here, my lord, the respondent, insurance company, examined only one witness. DW1, he is the, my lord, investigator of the insurance company. DW1, the lone witness of respondent, is the investigator of the insurance company. He was examined as DW1. Here, my lord, the judgment transfers one name, Syed Ali.
Where?
In the internal page 3, my lord, your lordship will turn to internal page 3 of the judgment. The second para I am reading. In the middle, your lordship will find during investigation, he collected, means that investigator of the insurance company, DW1. During investigation, he collected certified copy of FIR, which was filed by ESI Dronabora of Dhula PS in connection with PS case number 127 of 2006. It transfers from the certified copy of FIR Exhibit A that one Syed Ali, son of Abiruddin of Khatuniyarpara village, informed that the bullock cart was knocked by an unknown truck. This line is important, my lord. Your lordship will note. This Syed Ali informed, but that Syed Ali was not examined by the respondent. He was not even the eyewitness. He was not in the bullock cart. In the bullock cart, one person was there with the deceased. His name is Latifur Rahman. Latifur Rahman is the eyewitness. He was with the deceased in the bullock cart. He was examined as PW2. His evidence was not considered. One Syed Ali, who informed that unknown truck caused the accident. But that Syed Ali was not the eyewitness. He was not in the place of occurrence. He informed simply. And on the basis of that, tribunal has concluded. And respondent, my lord, respondent also did not make any attempt to examine that side ali. It was their duty. When they rely upon the information of that side ali ought to have been examined as DW, but the respondent has not done that. In the next breath, your lordship will find another name, my lord.
No, where is the name of Latifur Rahman?
Yes, my lord. Latifur Rahman, my lord, in the from the bottom of page 2, my lord. I am reading from the bottom. Issue number 1 and 2, both are taken together. Next para I am reading, my lord. Here your lordship will find the name of the Latifur Rahman. The last para in the page number 2, my lord, the bottom. It is in the evidence of the claimant that on the day of accident, while her husband accompanied by Latifur Rahman was coming towards the site of Dhula by a bullock cart, and when they stopped the cart at Khatuniarpara to attend to the call of the Nesar, a Maruti car bearing number sensor, which was driven at an excessive speed, knocked her husband, as a result of which he sustained grievous injuries and succumbed to the same. Admittedly, she has not seen the accident, and she examined PW2 Latifur Rahman, who accompanied the deceased. So, my lord, this Latifur Rahman, he is the eyewitness. He accompanied the deceased. He was in the bullock cart, and he stated that bullock cart was hit by the offending Maruti car. He also supported the version of PW1 and stated that at Khatuniarpara, a Maruti car driven at an excessive speed knocked both of them, and they sustained grievous injuries and were immediately shifted to the hospital. Usman Ali succumbed to the injuries. Deceased, name of the deceased, Usman Ali, my lord. Usman Ali succumbed to the injuries. The claimant produced Exhibit 1, police report, which shows that Maruti car bearing number so-and-so was involved in the accident, and Dhula PS registered a case by case number 127 of 2006 under section 279, 338, 304 A IPC, but the result of investigation is not known. At that stage, my lord, the result was not known. Subsequently, my lord, that case was disposed and the driver was accused, acquitted, my lord. Driver of Maruti car was acquitted. So, my lord, here your lordship will find the one eyewitness is there. He was examined as PW2 by the claimant. On the other hand, the respondent examined only one DW1, single witness, DW1, and he is the paid employee of the insurance company. He is the investigator of the insurance company, my lord. He investigated the case. And here, in the interim judgment, this has been observed by the MSCP. My lord, I am reading this para also, it is relevant.
Yes, I mean.
According to the insurance company.
Which para?
In page, internal page 3, second para. Internal page 3 of the interim judgment.
Yes.
Second para, my lord, I am reading. This para is most important. This is the crux of the case, my lord. According to the insurance company, the accident was not caused by the Maruti car, but was caused by an unknown truck who managed to run away from the place of accident. In support of their plea, they examined DW1 Hemanta Kumar Sharma, insurance investigator. Only this insurance investigator was examined as DW1, my lord, single witness of respondent. During investigation, he collected the certified copy of FIR, which was filed by ASI Dronabora of Dhula PS in connection with PS case number 127 of 2006. It transfers from the certified copy of the FIR exhibit that one Syed Ali, son of Abiruddin of Khatuniyarpara village, informed that the bullock cart was knocked by an unknown truck and one person died and another person sustained injury.
Here,
So this line is
No.
important, my lord, your
no,
lordship,
no.
kindly.
Here, after considering your submission, the copy of charge sheet has to be perused by this court
Right.
under Order 41 Rule 27B. When court requires a document to be produced in appeal, because the allegations made are very grave, and prima facie what the documents, the letter produced by learned senior additional government advocate shows that charge sheet was laid in the case which was initiated on the direction of the tribunal. Against whom charge sheet has been laid? Aring police officer only.
Yes, yes. Against the police officer who issued the accident information, who filed the search sheet against the driver of the Maruti car. Against him, search sheet was filed.
So facts are peculiar, therefore the copies would be necessary.
That's why, my lord, my suggestion would be actually the MSCT ought to have waited for the investigation by the facts finding authority. Facts finding report ought to have been called for from the investigating authority. That was not done. Our claim petition dismissed and CID was directed. Means, my lord, only our claim petition was dismissed. On the other hand, the case was kept alive. So both the things are, my lord,
Okay.
not judicious.
Okay, heard Mr. J. Mullah, learned counsel for the appellant. Also heard Mr. K.K. Bhatto, learned counsel for respondent number 1, as well as Miss D.D. Burman. How you are?
As per earlier order, dated lordship.
You are not a party.
No.
You
Government has been made party of the last occasion.
Okay. Miss D.D. Burman. Appearing for the state of Assam, was made respondent number 4 in pursuant to the direction of this court by order dated 9/2/2026. Learned senior additional government advocate has produced a letter received by her from the Deputy Superintendent of Police, headquarters come officer in charge of CID Police Station Assam, Ulubari, and has submitted that the CIDPS case number 4/2015, which was registered on the basis of directions passed by the Motor Accident Claims Tribunal in the impugned judgment, and impugned judgment has been culminated in filing of the charge sheet under section 120B/420 IPC, read with section 98 within bracket small a /992 within bracket 3 of the Assam Police Act against the investigating officer who did the investigation in respect of the case which was filed against the driver of the Maruti vehicle bearing registration number
ES-20/A-7031.
Stop. Since the submission of learned counsel for the appeal, next para likhibo. Since the submission of learned counsel for the appellant is that the tribunal, the Motor Accident Claims Tribunal had erred in passing the impugned judgment by not considering the deposition of PW2 Latifur Rahman, who was stated to be accompanying the deceased and was eyewitness to the accident. And since, on the other hand, learned counsel for the respondent number 1 has submitted that it was one Syed Ali who was the eyewitness of the accident, and the Motor Accident Claims Tribunal has correctly come to the conclusion that the case filed by the appellant is a collusive case along with the concerned police of the Dhula police station. And since in the and since from the document filed by the learned additional senior government advocate, it appears that charge sheet has been laid in the said case. It appears that the said documents are required to be produced before this court so that after considering respective pleas of both the sides, an appropriate judgment may be pronounced in this appeal. Accordingly, where the charge sheet has been filed, accordingly, let the scanned copy of the charge sheet laid in
Judicial Register, Kamrup Metro.
CIDPS case number 04/2015.
25.
2015 or 25? CIDPS case number
15.
2015, along with the
2015.
along with the scanned copy of the case diary of the said case, be called for from the Court of Learned Chief Judicial Magistrate, Kamrup Metro. The registry to take steps for requisitioning the scanned copy. The hearing of this appeal shall be conducted only after receipt of the aforesaid scanned copies. List this matter on 26th of March.